Hello everyone, welcome back to the channel again. So in the previous video we have already covered Yojana part 1. So if you haven't seen that video, please go and see the video first. Okay. So Yojana September we are covering, and the heading of the September magazine is governance and the reforms. Okay. So in the last video we have already covered Nyay Bandhu, free legal aid and advice, making of a bureaucrat. Okay, that we have covered. Then we also covered accountability and financial administration. So this also we have covered in the last video, and parliamentary committee, which where we have to start from this particular video. Okay, so we studied in the last video about the CAG, also the CAG, and I asked you certain questions regarding CAG and the other things in the video. So please do answer in the comment section. So we'll start the video. So the first topic is parliamentary committees, strengthening the scope and the role. So as you already know, there are certain parliamentary committees. Okay, so please do let us know in the comment section in which article the parliamentary committees are mentioned. So parliament functions in two modes: on the floor of the house and in committees. As you know, what are the major parliamentary functions? What are the major functions of the parliament? It is to make the laws. Okay, law making power. But committees are also there in the parliament. Their function is to scrutinizes the bill which is referred to them by the parliament, and reports submitted by the committees allow for informed debate in the parliament. Also remember this. So whatever the reports committees are presenting to the parliament, it can also be debatable. Additionally, committees provide a forum to build consensus across party lines, develop subject expertise, and consult with experts and the stakeholders. So this is also additional function of a parliamentary committees. So they try to develop a consensus between the party lines: BJP, Aam Aadmi Party, Congress, Trinamool, whatever parties are there, and whatever the party members are present in that committee. So whatever the concerned bill is there referred to them, it will be like a consensus. Like it should be everybody should agree on that particular bill. For example, women reservation bill, which is passed by the government. Hence, parliamentary committees serve an important role in scrutinizing the work of the government and improving the qualities of the bill before the parliament. Remember this. Now the question is, what are these parliamentary committees? How many types of these parliamentary committees? So there are two types of parliamentary committee. One is standing committees and one are ad hoc committees. Standing committees are the permanent in nature, and ad hoc committee are the temporary in nature. Temporary means what? Means whenever the their need will arise, that time only they will form the committee, and after that they will disband the committee. Okay. So standing committee can be broadly categorized into four, like subject one. This is also called as the department related committee. Second is financial one. Financial one has three committees. Like then there is a committee in on accountability, and last one is administrative. So four types of standing committee we have. Parliament may also form ad hoc committee, as I told you, from time to time. These committees are appointed either by either house of the specific purpose, whether it will be appointed by the Rajya Sabha or the Lok Sabha. For example, the Jan Vishwas Amendment Bill 2022 was referred to a joint parliamentary committee, and which is, you can say, it was an ad hoc committee, and later on that committee was disbanded after submitting the report. So this is the main purpose of the ad hoc committee. Whenever the need will arise, that time only they will come, and later on they will disband those committees. Now we'll see some brief about the department related committees. So these are the subject committees or the department related committees in ensure the oversight over each ministry. Okay, so they will see whatever the ministry is working, how the ministry is working regarding bills, regarding acts and everything. A minister is not eligible to be a member, remember this. So in most of the committees the ministers are not eligible to be a part of the member, okay, of these committees. So there are totals 24 department related committees, and each committee has 31 members, where 21 from the Lok Sabha and 10 from the Rajya Sabhas are there. So this fact you have to remember. Now, membership in committees is allocated to parties in proportion to their strength in the house. So, whatever the membership will be there in the committees, it will be allocated to parties in proportion to their strength in house. For example, BJP has the highest in number in the Lok Sabha. So, from Lok Sabha, they will get the higher number of members in the particular committee. On the other way around, which party has the less members, so they will be having a less number. Okay, so remember this. The next point is to ensure proper scrutiny of bills before passage. They can be referred to a subject committee for a detailed examination. So usually if you see many times opposition will be complaining about the scrutinization of a particular bill by a parliamentary committee. So this is what does it mean. Okay, it means the government is not following the proper, you can say, Lok Sabha or the Rajya Sabha or the parliament procedure. And what they are doing, they are just bypassing the standard procedures with respect to the passage of the bill. Okay, so this is one of the accusation made by the opposition. Now we'll see different committees. Number one is financial committees. It consists of three committees. Number one, estimate committees, public undertakings, and the public accounts. A minister, again, it is not eligible to be a member of this particular committee. The estimate committee examines pre-budget estimates of ministries. Remember word here, pre-budget. Before budget, whatever the estimates are there, that will be examined by the estimate committee. The committee on public undertaking examines the functioning of public undertaking. So they will examine the whatever the public undertakings are there. Okay, their functioning, it will be examined by the committee on public undertaking. And there is also a public account committee where which reviews the government spending statement approved by the parliament. Okay, so whatever the you can say money allocated to the parliament to spend, that will be scrutinized by this particular committee, which is public accounts committee. So remember this thing. And UPSC in mains, they have already asked the function of PAC. So they have already asked the function of estimate committee, so please remember this. So there are other committees such as committee on privileges also. So again, one more question. The privileges are mentioned in which article in the constitution? This is the next question, and you have to answer in the comment section below. So parliamentary or the committee on the privileges examines the question involving the breach of rights, privileges, immunities enjoyed by the members of the parliament. So many times member of the parliament, they uses their rights under you can say privileges under one article. Then article is your homework, so please tell in the comment section. The committee on petitions examines complaints sent to it form in the form of petition by the public. So there is a committee also on petitions which examines the complaint which is sent to them by the public only. So now we'll see what are the suggestions regarding this committee functioning and all. Number one, referring up all bills to committees. As I told you, the government is surpassing the bills by not sending the bills to the concerned committees. So this is one such suggestion, like refer all the bills to the committees. So currently bills are not automatically referred to a committee. The decision whether a bill should be referred to a committee depends on the decision of the speaker. Very important fact for your examination. In consultation with the minister presenting the bill. So if suppose Amisha, honorable home minister, he has presented a bill, so he will tell whether the this particular bill will go to the parliamentary committee or not. So during 17th Lok Sabha, until the end of monsoon session of 2023, 17% of the bill have been referred to the committees. This number is been declining. Okay, it is continuously declining. Then discussing the recommendation made by the committee or specifying the reason for rejecting certain recommendation is also not mandatory. So the problem is either you are not sending the bills to the committee, or if you are sending whatever the recommendation they are giving to you, the government is not bound to accept those recommendations. So that's why it is not mandatory. So again, National Commission to review the working of the Constitution 2002. It is also known as Venkatachalya Commission. Okay, I asked you in the previous video regarding this. So this is the answer for this particular committee. National Commission to review the working of the Constitution, also known as Venkatachalya Commission, noted that all bills introduced in the Parliament should automatically be referred to subject committees. So they have also recommended whatever the bill you are referring, it should be automatically go to the referred subject committees. Okay. Further, subject committee should also review the implementation of law passed by the Parliament in their respective subjects. So there should be a review whatever the implementation of the law is there, which is passed by the Parliament in their respective subjects. In some parliamentary systems, such as the United Kingdoms, all bills other than the money bills are automatically referred to such committee. So why they are telling you should refer the particular bill to the committee, okay, whatever the bills are there of the government to the committees, so that the accountability should be more. The accountability should be more, the transparency should be more. Okay, the transparency should be more. So this is the main reason behind that, so that the Parliament should not make any law which is, you can say, unconstitutional in nature. Attendance of MPs. So this is also one of the concern where the MPs are not, attending the parliamentary sessions properly. So the attendance of MPs in committee meeting is low. 17th Lok Sabha of July 2023, the average attendance for subject committee meeting was only 47%. The attendance in financial committee dropped further to 37%. So this is the, you can say, conditions in our parliament. So people choose their representative so that they can be voice in the parliament for their people, but ultimately what is happening, once they are elected, they are just surpassing the parliamentary proceedings, the committee proceedings, and etc and etc. Okay. Also, the National Committee to review the working of the Constitution report observed instances where a single committee encompassed too many ministries. So this is also there. I think we discussed in the previous video also, like one committee is assigned too many ministries to handle. So this is also there. Next, shortage of technical staff and experts. So again, Venkatachalya Commission recommended that funds be secured to assist these committees in conducting inquiries, holding public hearings, and collecting data. But the problem is there is a shortage of staffs, experts, even the money also. Currently, technical support available to parliamentary committees is limited to a secretariat that helps with the scheduling meetings and taking notes. So this is only technical support is only there up to a secretariat level. Next, this is in contrast to other democracies like Canada, where the Library of Parliament provides research staffs to all committees on request. So this is the example of Canada, and which is this is a very good thing about Yojana magazine. They are providing you the internationals, you can say, examples, so which you can quote in your examination, in the mains examination. Okay. Next is public transparency. So committee reports are usually made public, but the internal working of the committee may not be transparent. So this is the main problem, like committee reports which are usually made public, but internal working they will not make it as a you can say transparent or public. Therefore, again, Venkatachalya Commission recommended that major reports of all parliamentary committees should be discussed in the parliament. Okay, special where there is a disagreement between any committee and the central government. So where the committee versus central government question is there, that particular report should be discussed in the parliament. In Canada, again, example from outside or international, Parliament allowed committees to broadcast their proceedings within guidelines established. During COVID-19 pandemic, the United Kingdom had live coverage of the Health and the Social Care Committee on the country's preparedness for the pandemic. So this is something called transparency, okay, which is shown by the Canada or the United Kingdom Parliament. Next, reforms for parliamentary committees. So Venkatachalya Commission recommended certain reforms for the parliamentary committees. Like these include the establishment of a three new committees. Number one is Constitution Committee, Committee on National Economy, and Committee on Legislation. Now, what the Constitution Committee will do? It will check the constitutional amendment bill passed or presented by the government of India or whatever. Committee on National Economy, it will check the whether the economy is rising, declining, okay, failing, whatever concept related to the economy, that will be scrutinized by the Committee on National Economy. And the third one is Committee on Legislation, whether the government or the, you can say, ruling party, they are following the parliamentary procedures in a rightful manner or not. Next is the committee noted that it may not be necessary to continue the existing committee on estimates, public undertakings, and subordinate legislation, as the topic covered by them can be covered by subject committees also, or the proposed committees also. So this is the second thing they are telling. Like we should not necessary to continue with the estimate committee, public undertaking, or the subordinate legislation committee, because these particular topics are already covered by the subject committees or the proposed committees, means these three committees. So what Venkat Chelia Commission is telling, instead of estimate committee, public undertaking, subordinate legislation, there should be new committees, which will be Constitution Committee, Committee on National Economy, and the Committee on Legislation. So this is a particular recommendation given by the Venkat Chelia Commission. The recommendation has not been implemented. Okay, so this is also there. So please revise this chapter from Lakshmikant also, very much important for your examination. Revise the chapter on you can say parliamentary committees from Lakshmikant, and do let us know in the comment section which committee has the highest member in them. Okay, highest member, which committee has the highest members. Next is all about Digital Data Protection Act 2023. So in India is moving towards digital revolution. We are in the digital revolution. 5G is already there. You can say other UPI transactions, and most of the things we are having on the digital platforms. So privacy is something which is very much concerned. So there is a case called Puttu Swami case. Okay, so Puttu Swami case of 2017, where right to privacy where right to privacy made a fundamental right under article number 21. Okay, so remember this. Now we'll see what is this all bill about. The Digital Personal Data Protection Act 2023. The act provides for the processing of digital personal data in a manner that recognizes both the rights of individuals to protect their personal data and the need to process such personal data for the lawful purposes. So what they are telling, the Act provides for the processing of the digital personal data in such manner which recognizes both the rights of the individual also to protect their personal data and the need to process also such personal data for a lawful purpose. Means where you have ultimate control to deny your personal data, and the second thing where you don't have the particular laws, where you don't have the rights to deny your personal data, like national security and all these things. So remember this. The act protects digital personal data, that is the data by which a person may be identified by: number one, fixing obligations on the data fiduciaries, that is person, companies, and the government entities who process data for data processing, that is collection, storage, or any other operation or personal data. Number one is there should be a obligations on the government, person, and the companies how to process and what data to process regarding a particular personal or individual. Okay, so it in terms of collection, storage, and any other operations. The rights and duties of the data principals, that is the person is to whom the data relates. So this is the second point. The third one, the financial penalties for breaches of rights, duties, and the obligation. So when any company or the government breaches any of the rights, any of the duties, any of the obligations, then they are also liable to pay the penalties to the aggrieved person. Okay, remember. The act is based on the seven principles. Number one, the principle of consented, lawful, and transparent use of personal data. So you can say the body, the government, the particular company will ask your permission. Like usually what will happen in, if you see your mobile phone when you install a new application, so it will ask you to, allow notification, allow contacts, allow this detail, that detail, and usually you will not see and you will just click on allow. So this is what they are telling about the consent. Okay, so be careful when you are allowing such all these things. Study about those things because it is a matter of your security. Okay, second thing is the purpose of the principle of purpose limitation, that is use of personal data only for the purpose specified at the time of obtaining consent from the data principle. Means if a company has asked, like, your date of birth will only be taken away by the company, so it should be only your date of birth, not your mobile number, email, or other things. So this is what they are telling the limitations. Third, the principle of data minimization. So collection only of as much as personal data as is necessary to serve the specific purpose. For example, many of the apps, it requires the services they are providing is like a, you can say, screen recorder. So screen recorder, what they want, what permission they should require, number one is your screen permission, second is your mic permission, and your some of the files permission. But usually what will happen, these apps, they will also ask your, media permission, where you store your photos and images and everything, contact information, so they will ask your contact also. So this is what they are telling, like data minimization should be there. Means whatever is required for the particular service or thing, that much only data you should ask from the user. The principle of data accuracy, so ensuring data is correct and updated, so data should be updated and correct also. The principle of storage limitation means storing data only until it is needed for the specified purpose. For example, you have deleted the app, but there are chances like the data is not deleted by the app itself. The data is still with the company. So once you are no longer user of that particular app or the services, it is on the company's, you can say, obligation, or it is on their responsibility to delete all those data which they have taken from you. Next, the principle of reasonable safeguards. So to provide you the reasonable safeguards, the principle of accountability through adjudication of data breaches, breaches of the provisions of the act, and imposition of penalties for the breaches. So accountability means if any data breach will be happened to you or done by the company, then there should be a penalty given to the concerned aggrieved person. Best example is, PUBG was banned in India. So why PUBG was banned? Because PUBG was taking the data and it was sending the data to the China. TikTok was banned in India because most of the people, they were not understanding how TikTok is losing, you can say, taking their particular data and sending to the China. So this is something where the accountability should be measured. By using the word she instead of he, for the first time it acknowledges women parliamentary law making. So in this particular act, they have used the word she instead of he. So they also recognizes the woman parliamentary law making person. Okay. The act provide for the following right to the individual. Number one, right to access information about personal data processed. So you have your right to access the information regarding how much or what are the data processed by the company from you. The right to correction and erasure of data means you have all responsibility, you have all the powers to ask the company to remove your data from a particular platform. And the right to grievance redressal, in case they deny, you can approach the concerned authorities. And the right to nominate a person to exercise rights in case of death or incapacity. Suppose a person A died and he is a very big personality, so definitely he might have told someone, if I die or if something happened to me, he is the concerned person who can use my particular social media handle or whatever the data processing platform he is using. The act safeguard the personal data of children also. The act allows a data fiduciaries to process the personal data of children only with the parental consent. So regarding children, the parent consent is very much important. So remember this. Next is Law Commission of India. So the Law Commission of India is a non-statutory body. It is constituted by a notification of the Government of India under Ministry of Law, Justice and Department of Legal Affairs. Okay, so remember that it is a non-statutory body. So there are three types of body. One is constitutional in nature, statutory, and non-statutory or extra constitutional body. For example, Niti Aayog. Okay, study about this from your Lakshmikant. The commission makes recommendation to the government in the form of reports as per its terms of reference. So remember this. Then the government has constituted the 22nd Law Commission of India for a period of 3 years. Okay, so with effect from 21st Feb 2020, the term of the 22nd Law Commission has been since extended up to 31st August 2024. So you can say 22nd Law Commission, the term is extended up to 31st August next year 2024. The composition of the 22nd Law Commission of India is as follows: a full-time chairperson and 4 full-time members will be there, including members and secretaries. Secretary Department of Legal Affairs will be there as ex officio member. Secretary Legislative Department as ex officio member, and not more than 5 permanent part-time members also there. So usually UPSC will not ask questions such from statutory body, but still, if you are able to remember the members and what are the chairman and the members, how many members are there, it is well and good. Next article is very important, which is related to your direct tax. Now, what is direct tax? Please do let us know in the comment section. And for those who don't know, I will tell you there are two types of tax in India: direct tax and indirect tax. Indirect tax, where incidence and impact lies on the different people. For example, as a customer, I am buying certain, you can say, commodities, certain products from a shopkeeper, and I am paying him a money. In the bill it will be included your particular product is inclusive of the GST. So I paid the GST, now he has to pay to the government. That is called indirect tax. Now direct tax, where the incidence and the impact lies on the same person. For example, I am a you can say businessman, and I am earning the money, so it is my duty to pay the tax. So incidences lie on me also, and impact also will lie on me also. Okay, so this particular article is all about tax reforms. So in direct tax, the government of India has undertaken substantial tax reforms in the last few years to ensure that tax collection increases in a non-adversarial manner through a stable and predictable tax regime. So government, and I think the government is somewhere, you can say, unable to increase the tax base in India. Very less people are there in the country who pays actual, you can say, direct tax. So this is something where the government is planning like to increase the tax base in India. So there are certain suggestions by these tax reforms that we will see. Number one, removing exemptions, deductions, and reducing the tax rates. A study report to the G20 Development Working Group by IMF, OECD, UN, and World Bank in October 2015 concluded that tax incentives are often found to be redundant in attracting investment in developing countries. So they are telling these tax incentives should be stopped. Okay, these tax incentives harm the revenue raising capability of developing countries. So this is one such problem, as they lead to unhealthy tax competition, a race to the bottom. So this is suggested by the IMF, OECD, UN, and World Bank. Based on the budget speech of the Finance Minister 2015-16, the process of removing exemptions and deduction for corporate taxpayer was started. So they have already started regarding corporate taxpayers and the big businessmen and all. Okay. Similar reforms were carried out in personal income tax in 2020 also, by providing an option for taxpayer to shift to the new tax regime with lower tax rates but without any exemptions and deduction. So please study about what are the new tax regime and what is the older tax regime. I think UPSC in 2021 they have asked this particular question in mains examination. Okay. Next, the Finance Act 2023 has further reduced the tax rates in the new tax regime to make it more attractive. So Finance Act 2023, please study about that. What is this? During COVID, many countries were advocating imposing new taxes. However, the government continued its resolve to provide a stable tax regime. So in India, during you can say COVID time, when the many countries were advocating imposing new taxes, but in government continued its resolve to provide a stable tax regime. So people usually complain regarding the taxation in India is very much bad. But if you compare with the other world or other part of the world or other countries, India is quite phenomenal in terms of tax regime. Okay. Next, widening and deepening of tax base. I told you the tax base is very narrow, and there are also experts who used to say if direct tax we are able to increase to 17 to 20% in the country, which is now somewhere below 9 to 10%, if I am not wrong. Okay, then there is no need to take the GST and all. So GST can be go if we are able to increase the direct tax up to 20% in the country. 20% means 20% of the population. Government has taken various steps to widen and deepen the tax base. Some of them include new tax deduction at source, that is TDS, and tax collection at source, that is TCS. Provisions have been introduced. So please study about what is this new tax deduction at source and tax collection at source. What is the difference between the two? The black money, which is called undisclosed foreign income and assets, and imposition of tax act, you can say 2015, was enacted to deal with the problem of undisclosed foreign income and assets stashed abroad. Okay, so this is the second step. Third one, the third party information collection mechanism has been strengthened to collect information undeclared income or assets. So regarding third party, you can say information collection mechanism was strengthened so that the collection information of undeclared assets or money will be more under the radar in the or for the under the government of India. Various amendments have been made to encourage the use of digital transactions in place of cash transactions. So digital transactions when you are doing, it means there are chances the corruption will be less. Next, using technology to increase efficiency of the income tax department. So compliance to reporting has been provided to ensure that the taxpayers pay their fair share of taxes. Fair share means if you are liable to pay 10% of the tax, you have to pay 10%. If you are liable to pay this much amount of tax, you should pay that much amount of tax only. The income tax department has taken a number of initiatives that have helped the taxpayers comply with tax laws voluntarily. So this is what the government or the income tax department has done. Then an e-verification scheme has been introduced with the facility to update returns with some additional tax. Okay, so it is also there, e-verification scheme. Then there is a faceless system of assessment and appeal has been started to bring efficiency to the process. Okay, so faceless system because people they are hesitate to come in front of the regarding authority or whatever. Next, reducing litigation by providing tax certainty. So there is a advanced pricing agreement which has been a success story in reducing the litigation in transfer pricing. Okay, the government has also introduced amendments to provide the certainty on various issues to reduce the tax disputes. So regarding transfer pricing means that whatever the tax amount is there and how much is transferred by the particular firm or individual. So advanced pricing agreement is also there. In just about 1 year time, more than 30 lakh updated returns have been filed and tax dues have been paid. So this is a quite phenomenal work by the government. Next, result of these reforms. The tax collection in the direct tax has shown a significant increase. having buoyancy of more than 1 year, more than one over the years. Okay, so what they're telling in simpler example is the tax base has now increasing. More people are coming forward to pay the taxes. This means over a longer period of time, direct tax growth is higher than the growth in GDP. Growth in GDP is 6.6%, 7%, 8%, whatever, but direct tax growth is more than that. This indicates efficiency in tax collection as well as positive impact of the direct tax reforms. So it can say direct tax reforms are, you can say, quite successful in nature. Next, during the period 2013-14 to 2022-23, direct tax collection grew from 6.39 lakh crores to 16.61 lakh crores. That is growth of over 160%, giving long-term direct tax buoyancy of 1.15. This is higher than one. Tax buoyancy signifies efficiency of tax administration and success of various tax reforms. Now, what are the future challenges? Tax policy reforms is a continuous process. More reforms are contemplated along the above lines in order to ensure that the direct tax collection remains buoyant. Okay, it should be there, it should be efficiently there. Ease of doing business is also one area where tax policies are required to continue to pay attention. So this is one of the area where the government should think more of that. Now come to the next article. It is all about protecting the interest of the consumers and businesses. So the competition law aims to protect the interest of both consumers and businesses by fostering a competitive environment in market and preventing anti-competitive practices. What are anti-competitive practices? Only one company is there providing all the services. There are no other, you can say, players in the market in terms of communication or internet or service provider. You will see either Geo company is there or Airtel is there. Vodafone is totally, or you can say, more or less dead now. Okay, so this is something like anti-competitive practices. Just imagine if 5 6 service providers are there. So there are chances where today you can say 1 GB net is 9 or 10 rupees. It might be 4 or 5 rupees. It may be more reduced. So this is something called competitive environment in the market. Just imagine you're buying clothes only from one store. There is no other such store nearby you. So what will happen? He will definitely put, you can say, prices more than what is required, or what how much should be assigned to that particular product. So this is what they are talking about. It ensures free competition, a level playing field for all market players, thereby encouraging innovation and efficiency. The law is enforced by the Competition Commission of India, and there is a particular case with respect to Competition Commission of India versus Google. Please study about that case. What is this case about? Competition Commission of India versus Google. Okay, so Competition Commission of India mandates includes preventing anti-competitive practices, promoting and sustaining competition, and protecting the consumer interest. So this is one of their aim or their objectives. Second, a robust competition mechanism helps in regulating mergers and acquisitions to ensure that they do not negatively impact the competition or consumers. So false practices, okay, attracting the consumer by false means, false, you can say, advertisement and all those things. Everything will be under the radar of the Competition Commission of India. CCI advocacy initiatives and policy recommendation further promote pro-competitive policies and protect the consumer interest. Now we'll see what are the roles of CCI in markets and its tools. So Competition Commission of India derives its power from the Competition Act 2002. Okay, and since its inception in 2003 to develop and flourish an ecosystem of healthy competition in Indian economy, the concerned authority, Competition of Commission of India, is working. The Modern Competition Act 2002 focuses on checking and correcting abuse of dominance by market entities which can harm the competition in India. I told you the case of Google. Okay, one such case is it is a very huge case. You should study about that case. Now we'll see what is international cartel. So an international cartel is said to exist when not all of the enterprises in a cartel are based in the same country, or when the cartel affect market of more than one country. You can take the example of MACD. Okay, whatever the companies where they are telling all of the enterprises in a particular cartel. Cartel basically means it's a package of multiple, you can say, markets, food market, apparels market, okay, automobile market. So if a particular cartel is present in more than one country, so it is called as an international cartel. CCI uses a variety of tools and mechanism to fulfill its mandate. Number one, advocacy. So they will provide you particular, you can say, advocacy booklet. They will provide you advices by lawyers, advocates, and all. So that is advocacy. So CCI publishes advocacy material for guidance and use by stakeholders. Second, anti-competitive agreement detection. So monitoring and investigating agreements, competitors that may violate the Competition Act 2002, such as cartels, price fixing, bid rigging, market allocation schemes, risk, resale price maintenance, etc. So these are certain, you can say, cartel, only these many people will work in this particular industry. Okay, price fixing. So so that the consumer will not get the chance or the choices to, pay other thing. So everybody is fixing the same prices, whether you buy a pant from, shop A or shop B, they will charge you the same price, so you will not get the choice. Okay, so all these things are there. Third one, abuse of dominance assessment. So scrutinizing the dominant firms. I told you, for example, in India, Jio is one of the dominant firm. Airtel is also there. Then what else? Write down in the comment section. To ensure they do not exploit their market power to harm competitors or exclude new entrants. For example, I think yesterday or in yesterday news it was there, like Domino's, they have reduced the their pizza amount which they were charging for the medium pizza or the large pizza, because many competitors are there. So this is a good sign for the Indian consumers. Now you have more option for the pizza deliveries and all, so that these particular companies, they will not charge you more and more. Next, fines and penalties. In case of abuse of a dominant position, the CCI can impose a penalty of up to 10% of the average turnover for the last three preceding financial years. Okay, so this is also there. They can impose the penalties, and when you study the Google case, you will get to know what are those particular penalties and everything. For cartels, CCI may impose a penalty up to three times the profit or 10% of the turnover for each year for the of the continuance of such agreement, whichever is higher. International cooperation. So CCI also entered with the many international, you can say, foreign players or the companies regarding to facilitate the international cooperation. Then merger control. So CCI evaluates whether the proposed transactions may cause an appreciable adverse effect on the competition, harming consumer welfare or not. So they also control regarding this particular merger and all these things. Remedies. So remedies will be given. Okay, requiring companies to take corrective actions, divest asset, or making structural changes to address competition concern identified by the CCI. Next, competition and consumer protection. So while the competition law doesn't explicitly address the consumer rights, it prioritizes the consumer's interest by fostering a market free from anti-competitive forces and abuse of the dominance. It endeavors to maintain the sufficient choice for consumers, very important word, choice, by sustaining competitive conditions in the market from the supply side. Next is relation between the competition and the business. So competition plays a very crucial role in shaping how businesses operate and interact with each other. Ola versus Uber services. Okay, in pizza there are two are there, Domino's versus Pizza Hut or whatever, and now I told you many are coming. Same way the other things. Then competition creates an environment where businesses are constantly pushed to improve, innovate, and meet the consumer needs effectively. Okay, so this is also there. Third, a well implemented competition regime is a catalyst for the entrepreneur markets, and the current startup economy of India is reaping the benefits of the active competition regulation mechanism in India. Further, better competition in the local market result in greater productivity and the growth, and increases the international competitiveness of the domestic businesses also. That's why government of India also promoting, like, normal local markets, local products. They are organizing hearts, where hearts, you can say, fair, many things are organizing also by the government of India, so that it increases the competition in the society, in the market, and the consumer as well as the business or the corporate world, they also benefit. Now, what is conclusion? As a linking law between businesses and consumers, competition law can be said to be boon for both. On the business side, competition helps businesses identify consumer needs and then develop new products or services to meet them. At the same time, which in turn allows customer to have access to the better choices. So choices, if the customer is having choices, it means that country, that market is in a very healthy competition. Remember this. So Competition Consumer Protection Act 2019, strengthening provision for consumer protection. To strengthen the provision for consumer protection, especially in the new era of globalization, online platform, e-commerce market, etc. are also included in this particular act. It replaced the Consumer Protection Act of 1986. Okay, now e-commerce platform are also there, Flipkarts and the other, you can say, e-commerce platforms. Under the provisions of the Act 2019, a Central Consumer Protection Authority, that is CCPA, has been established. This act was widen the scope of the definition of consumer to include person who buy or avail of goods or services online or through electronic means. I told you they have widened the scope, and now they have also included the e-services or the e-commerce platforms. It has also included the definition of advertisement as any audio or visual publicity, representation, endorsement, pronouncement made by means of inter alia electronic media, internet or website. So this is also include. Next, guidelines for preventing or misleading the misleading advertisement and endorsement. So CCPA has notified the guidelines for prevention of misleading advertisement and endorsement for misleading advertisement 2022. So they have released certain guidelines. Okay, it has been launched with the objective of curbing misleading advertisement and protecting the consumer who may exploit it or affected by such advertisement. So many companies, they use surrogacy advertisement, they use unfair advertisement. So to protect the consumer, certain guidelines are there. As per these guidelines, due diligence is required for the endorsement of advertisement. Means due diligence means what? Proper factual information, and whatever you are telling, it should be correct, it should happen. Okay, if the product is there, the use of that product should be in that way only. It has also advised to all marketplace e-commerce platforms to display information provided by sellers as per the e-commerce rules 2020. Before, many people, when they shop from the e-commerce platform, they felt like cheated or something. So that's why now they have to provide the information of the sellers also as per the rules 2020. Remember. So Consumer Protection e-commerce 2020 rules, we will see. Under Consumer Act, these rules have been launched by the Department of Consumer Affairs. Safeguards consumers from unfair trade practices in e-commerce platform. What is shown to you, that should only be delivered to you. Okay. These rules outlines the responsibilities of e-commerce entities and specify the liabilities of the marketplace and inventory e-commerce entities, including provision for customer grievance redressal. In case you buy an iPhone from an e-commerce platform and they have sent you a wooden box and nothing is there in that. So there should be certain, grievance redressal mechanism. So now it is there under e-commerce rules 2020. So you can go and approach the concerned, you can say company. If they denied, you can file the complaint against them. There is an emergence of unfair trade practices known as dark patterns, which involve, now what is dark pattern, which involves using design and choice architecture to deceive, coerce or influence consumers into making choices that are not in their best interest. Very nice example is, like, I think you might have seen in many of the ads, they have shown like the burger is this much big, the pizza is this much big, or the product is very beautiful, the color is very nice. But when it comes to you, the quality is not good. The pizza will be very small, the burger will be very small, the shirt color will be not matching what you have selected. So all these things are the dark patterns, what they're telling. The Department of Consumer Affairs has urged e-commerce companies to refrain from indulging in such activities which may fall into the category of dark patterns. Okay, so Department of Consumer Affairs, they have asked the e-commerce companies to refrain from, to indulge in all these practices. So in this particular thing, all these things we have already discussed, so you can go through this particular diagram to understand more better. Okay, so more power to consumer, more power to consumer. So how more power to consumer under Consumer Protection Act 2019? Okay, what are the other areas, whatever the other rules, like this is for e-commerce, this is for manufacturer services, okay, and this is for CCPA, and this is regarding the act of 1986. So we discussed already all these things here. Next is administrative reforms. So administrative reforms, again your governance part. So in the last decade, India has undertaken the transformational reforms with e-governance models. UPSC asked in mains 2023 regarding e-governance. So with e-governance models, simplifying the citizen interface with the government and bringing the government and citizen closer. The central government e-governance models like Ayushman Bharat scheme, PM Jan Arogya Yojana, PM Jan Dhan Yojana, One Ration Card, Passport Seva Kendra have been successful in bringing the transparency and openness to the government processes. So these are the examples you can quote in your mains examination. Next, the Prime Minister has adopted the policy of maximum governance and minimum government. Okay, which envisages a digitally empowered citizen and a digitally transformed institution, radically changing India's governance landscape in scale, scope, and learning paradigms. Remember this. Effective redressal for public grievances. Centralized public grievances redress and monitoring system is there. Okay, so it will be implemented across all central ministry and department, attached subordinate or autonomous bodies also. So 18,19,104 grievances were received by all ministries, departments, states, UTs of 15,68,097 were redressed in 2022. The average disposed time of central ministry and department has improved from 32 days in 2021 to 27 days in 2022. So the things are working more better. The 10 step CPGRMs reforms adopted to improve the quality of disposal and reduce timelines had a significant impact. Okay, so it brought reforms regarding compassion, empathy, science-based solutions to enable the effective grievance redressal for the public. The parliamentary committee, very important for your mains points, you can pick up this. The Parliamentary Standing Committee of the Ministry of Personal, Public Grievances, Pension, in its 127th report submitted to the Parliament in March 2023, appreciated the 10-step reform processes adopted by the Department of Agriculture, Administrative Reforms and Public Grievances for improving the quality and disposal of grievances and reducing the timeline. So this timeline they are talking. The Parliamentary Standing Committee also commended the department for its faster rate of disposal grievances, which is over 1 lakh per month. Okay, so remember this. And one more thing important here is Sevottam scheme or Sevottam model, where operationalizing the feedback mechanism and the CPGRAM's dashboard. Okay, so I mean, too much information is there in the Yojana, but only thing you have to remember the reforms in the governance or the e-governance sector. Next is benchmarking governance. The DARPG undertakes the biannual assessment of the governance of states and the UTs through the Good Governance Index. Okay, so DARPG is there, which releases the Good Governance Index. It assesses the governance at the district level through the District Good Governance Index and assesses the delivery of e-services through biannual National E-Services Delivery Assessment. So remember this. National E-Services Delivery Assessment assesses the state e-services delivery across the nation. Okay. Then there are certain sectoral reforms or the secretariat reforms. The government implemented deep-rooted secretariat reforms. Then there are focusing on delayering, delegation of you can say financial powers, e-offices, special campaign for institutionalizing the Swachhata and the minimizing the pendency of the services. Then Chintan Shivar is there. Chintan Shivar lays down the futuristic model of governance, representing far-reaching administrative reform in the Kartavya Kal period. Kartavya Kal means this is your time where you have to perform more and more. Civil Services Day, 21st April. Every year we celebrate the Civil Services Day again, so that the civil servant perform better and better. So, Viksit Bharat, empowering citizens and reaching the last mile. Okay, so you can go through because too much is there. You should only have a 4 or 5 points which are very much important. So please study from all these. You can pause the video and you can study from here. The Abhinav Pahel series on Sunset TV. It is a 15 you can say PM award winner interacting with the beneficiaries about the benefits of the successful initiative. So you can go and watch this particular series. Okay, so study about this. The next article is women empowerment recent reforms. So we'll see the women empowerment recent reforms also. One of the hot topic of UPSC continuously asking the women related issues and all these things. So we'll see. It is now when acknowledged that empowering a man leads to empowering a woman and individual, but empowers an entire generation. Very nice thought, very nice quote. You can use in your answer. Empowering a man leads to empowering a woman. Okay. Empowering a woman leads to an individual but entire generation. So if you empower a woman, you are empowering entire generation. Very nice. In order to empower women, successive governments have taken various steps. So we'll see first we will see this particular diagram. So there is a Protection of Women Act Domestic Violence, that is 2005, Prohibition of Child Marriage Act 2006, then the Muslim Women, that is Protection of Rights Act 2009, that is criminalization of the triple talaq. This is for our Muslim women and all. Then Protection of Child or Children from Sexual Offences Act 2019. Then Medical Termination of Pregnancy Amendment Act 2021. Assisted Reproductive Technology Regulations Act 2020 and the Transgender Person Act 2019. So these are the some of the acts which you can use regarding mains examination answer. First one is Beti Bachao Beti Padhao. It is a awareness campaign launched in 2015. The main aim is decline the child sex ratio and promote the education and the welfare of the girls. It is one of the successful campaign of the government of India. Next, Pradhan Mantri Matru Vandana Yojana, launched in 2017. This maternity benefit scheme provides financial assistance to pregnant and lactating women. Okay. Third, Mahila E-Heart. So this is the E-Heart, the online platform launched in 2016 to facilitate the women entrepreneurs and artisans in showcasing and selling their products. Okay. Ujjwala Yojana, launched in 2016. This scheme provides free LPG connections to women below poverty line household. Okay. Next, Stand Up India. Again, they can be an entrepreneur. So they can be entrepreneurs. So it offers the loans between 10 lakh and 1 crore to set up a greenfield enterprises. What is greenfield enterprises? This is your homework. Tell in the comment section what does it mean by greenfield enterprises and what are the brownfield enterprises. Now, changes in law. Number one is Criminal Law Amendment Act, that is Nirbhaya Act. So this law was passed in 2013, and they established the Nirbhaya Fund under this to support the initiative addressing the women's safety and empowerment. So the fund has been utilized to set up one-stop centers, women helplines, improve infrastructure for the women's safety. Remember this. Next, Maternity Benefit Act 2017. It extended maternity leave period for women working in the organized sector in India from 12 to 26 weeks. Okay, but there is a problem. The problem is most of the private players, when a woman working under them is pregnant, they will ask her to leave the job for a temporary period and then rejoin after the pregnancy. So they will not allow her to take the maternity benefits. This is happening in the country. Okay, remember this also. The Protection of Children from Sexual Offences Act 2019 to strengthen the protection of the children from the sexual offences. Next, the Muslim woman, I told you regarding the triple talaq. So it was made criminalized, the practice of instant triple talaq done by a Muslim husband. Sexual harassment of women at workplace, it is also there. Sexual harassment of women at workplace, and I think it is based on the Vishakha guidelines. So please study about the Vishakha guidelines, which particular case. Okay, Vishakha guidelines. Remember this Vishakha guidelines. Study about Vishakha guidelines. Now, what are the way forward? Ending child marriage. Efforts should focus on implementing and enforcing laws that set a minimum age for marriage, promoting a girls' education, raising awareness about the harmful consequences of the early marriage. Actually, in India, it is neither legal nor illegal, the child marriages. But if any of the minor is in not in favor of the marriage, then marriage cannot be done by the parents. Community engagement, targeted interventions, economic empowerment programs can empower girls and their families. Okay. Next, political empowerment. So, women reservation bill is the best example you can quote here. So, encouraging political parties to nominate more women candidates, provide leadership training, and addressing the systematic barrier are essential steps towards achieving equal representation in parliament and the local government or the state legislatures. So women representation bill is one of the women reservation bill is one of the best example which you can quote here. Economic environment, economic empowerment also should be there. The governments and the businesses should promote equal pay for equal work, which DPSP quote again. Tell in the comment section. Establish maternity leave, childcare policies, provide access to finance, entrepreneurship training for women, etc. Then encouraging women participation in traditionally male dominated sector and dismantling the barriers to career advancement will contribute to a greater gender equality in the workforce. For example, army, okay, air force. Here you can see now women are coming and leading also. Then sexual and reproductive health and rights. So to ensure that access to comprehensive sexual and reproductive health services should be there, which is crucial for women autonomy and well-being. Okay. Next is land rights. So property rights should be given to them. So government should enforce legislation that ensures equal access to land, property rights, and inheritance laws. Remember. Next is gender budgeting. To advance gender equality, countries should establish comprehensive system to track the public allocation for gender equality initiatives. Okay, so this is the last topic for this video, and I know the video is quite long, so please watch the video, and you can watch the video at 1.5x speed. It will definitely help you in your examination or the preparation. Okay, so next topic, Anusandhan. National Research Foundation Bill 2023. So, National Research Foundation will provide high-level strategic direction for research, innovation, and entrepreneurship in various fields. It will also provide scientific and technological interfaces in the humanities and the social sciences also. The bill will hike R&D spending in the country because in the budget it is not even a 1%. I think the R&D you can say will get in the budget. The act will establish the NRF, an apex body to provide high-level strategic direction of scientific research in the country. The Department of Scientific, uh, the Department of Science and Technology will be strength administrative department of NRF, which will be governed by a governing board consisting of eminent researchers and professionals across disciplines. The Prime Minister will be the ex officio president of the board. Remember this. So, regarding this particular board, the Prime Minister will be the ex officio chairman or the president. The Union Minister of Science and Technology and the Union Minister of Education will be the ex officio vice chairman or vice presidents. NRF functioning will be governed by Executive Council chaired by the principal scientific advisors to the Government of India. Obviously, an IAS officer. NRF will forge collaboration among industries, academia, government department, and research institutions. And the Act will also repeal Science and Engineering Research Board established by an Act of Parliament in 2008 and subsum into NRF, that is National Research Foundation, which has an expanded mandate and covers activities over above those SCRB. Okay. So this finishes your Yojana September magazine. My request to everybody, please watch these videos again and again so that it will help you to retain some of the points to write in the mains examination. And please do let us know in the comment section regarding the topics or the subject you want us to start the video. Okay, please comment down. Okay, we are waiting for your comment. So we will wind up this video. Thank you everyone. Do study well, and whatever your doubts are there, you can drop a mail also at domesticglobal 2022@gmail.com. Okay, so you can drop a mail regarding your queries, regarding your questions, which will be answered within 7 days. And regarding video related content, you can comment down and share also this video with your friends. So I hope you guys are doing with your studies, because there are only 3 months left for the 2023. Then you will enter for the prelims preparation from Jan or Feb. So please study well. Okay, bye, take care.